I'm going to quickly introduce the moderator for this panel that's going to be talking about the new GTLDs and ICANN. Christina Rosette is of counsel at Covington and Burling in Washington, D.C., where she specializes in domain name, internet, and trademark issues. And she is currently the president of the ICANN intellectual property constituency, where she has also been the IPC's GNSO counsel for 5 years now. She's played a leading role in trademark protection within the ICANN system, where she was actually a member of the implementation recommendation team, which was a collection of 18 trademark experts from around the world who were tasked with attempting to protect trademarks in the new GTLD rollout. She was also actively involved with the drafting of many new GTLD applications for several clients. And with that, I'm going to turn it over so she can introduce the other panels and we can get this started. Thank you very much.
Thanks very much, Russ. To my far right is Mike Silber. He is the head of legal and commercial at Liquid Telecom. He currently serves on the ICANN board of directors and was appointed to that position by the country code name supporting organization of ICANN. To my immediate right is Nick Wood. Nick is managing director of Registrar Cum Laude and consultancy Valideus, which is managing over 120 new GTLD applications, all for brand owners. And Nick was also a member of the implementation recommendation team, or IRT. To my left is Ellen Shankman. Ellen specializes in trademark and intellectual property law and is the principal of her own firm in Israel. She is currently a member of the INTA Board of Directors, was also a member of the IRT, has chaired the INTA Internet Committee, and has been involved in ICANN, I think, since before the very beginning. To my far left is Martin Sutton. Martin Sutton is a risk manager with HSBC Holdings, where he is responsible for all domain names associated with the group and ensuring that all possible measures of brand protection are being taken. He is currently president of the brand registry group within ICANN. And just to give a standard disclaimer that's going to apply to all of us, we're all here speaking in our personal capacities, not on behalf of our employers, our clients, or in the case of Mike, the ICANN Board of Directors or ICANN itself. So we're going to assume that at this point, everyone in this room has heard the acronym GTLD and that you know the basics. We're going to start, before we get into some of the more specific issues facing brand owners, we're going to kind of take it up to the macro level and talk a little bit about one of the issues that has really come into play in the past several months relating to the internet ecosystem, and more particularly internet governance, who manages the internet, and how and why do all of you in this room care? So with that, I'll kick it off to Mike.
Thanks, Christina. Yeah, I really wanted to take the very macro level, and it's not because I'm scared of the comments and criticisms that are going to come in terms of specific new GTLD implementation issues, but because I think some context is important, and I think many of the people in the room don't necessarily have the big picture. They've got a very specific focus. While that's not necessarily a bad thing, I think that context is quite important. So why is internet governance important? Well, ICANN commissioned a study performed by the Boston Consulting Group. I would encourage you to have a look at it if you want to understand the impact that the internet has on the global economy. It's called Greasing the Wheels of the Internet Economy. And the issue really is a single inclusive internet rather than multiple walled gardens in which cannot talk with one another. A single inclusive internet contributes to global GDP. You don't need to take a picture. You can go and download it from the report is widely accessible and available from the ICANN site and elsewhere. But governments in particular recognized from the beginnings of the internet as a small research, military and academic project. The internet has a greater impact on our lives. Governments like to know what's going on when things impact on their citizens' lives. Sometimes they like to control it, sometimes they just like to know what's happening, depending on the type of government you have in your particular country. So this question of internet governance and who's responsible for governing the internet has emerged in about 2003. It then reached a peak 2005, 2006 with something called the World Summit on the Information Society. I don't want to bore you with details, but it's come and gone in waves as to whether states should or shouldn't be involved in governing the internet, to what extent, what areas are the state's responsibility, what sits within private hands, and a lot of it has gone around what is referred to as critical internet infrastructure resources. Now, that's code for mainly globalizing the domain name system root. Different actors have different ideas of what globalizing means, but a lot of people get very scared with the fact that the majority of the DNS root sits still in the United States. There are multiple routes outside of the US. There are also multiple instances or copies of the root that sit all around the globe. But still, this issue is a significant concern within the global community. It's important, but it's not the only issue. We're also then starting to talk about internet resources and names. That pink section on the right-hand side is what ICANN does. And we use the IANA as the database to store ultimate data on that. But there are other issues. There are names and there are protocols. Now, the critical thing there is there's very little in the way of intellectual property rights within names and protocols. I haven't heard of anybody, maybe there is, who's gone and trademarked 192.168.10.10. But I'm not even sure it is capable of trademark protection given where it sits and how numbers are used. Similarly with the protocols, which are agreed internet protocols and standards used for the underlying communication across the internet, where very specific decisions have been made not to protect those protocols so that they become global, accessible, interoperable. On that basis, we as the organizations involved in the shared internet resources have some guiding principles that we've developed. The one is that we are stewards. We're not owners, we're not controllers, but we are stewards. We need to develop, we need to protect, we need to advance, and occasionally we need to control and regulate a little bit where appropriate. We work together. The I institutions, or sometimes you'll hear them referred to as the I-STAR institutions, being ICANN, ISOC, the Internet Society, the IETF, the Internet Engineering Task Force. These entities need to work together because they're common parts of this ecosystem. This notion of inclusiveness is that we do need to include governments in the public sector. We can't pretend that this is a private sector only initiative. We need to also include the techies, the guys who operate the internet infrastructure, the tier one internet service providers who run the big pipes over which almost all of the internet's data flows, the developers who are developing new technologies, new equipment, new protocols and new standards, civil society and users, and those are not necessarily always the same thing because civil society is often special interest groups, but how their voice becomes heard and how users and the community get included in this as well. And then also there's a notion, and it's something that's developed in the IETF and the way that the IETF has developed these protocols over the years, is that one cannot simply create a set fixed standard, but we all make mistakes. And the idea is develop, release, and iterate. So it's a process of continuous improvement, and if it means that we got it wrong, then let's fix it rather than casting it in concrete and defending things that we got wrong. There are multiple other internet governance issues. I don't want to go into huge detail because we could spend the entire session about it, and this is not an internet governance symposium. But there are a lot of issues at the moment which are not being addressed. They don't have a home. Things like spam, crime, privacy. And the first panel talking about intermediary liability was talking about some of those issues. And it was clear, brand owners have a role in protecting their brands, but they don't necessarily get the assistance they require from third parties. And it's not always clear who those third parties are or should be. But they don't always get the assistance they require, whether it's law enforcement or courts or politicians, whoever it may be. So because these issues don't have owners or homes, they sometimes land up intruding in places where they may not be appropriate. And we in ICANN find that we're often being told, well, you govern the internet, you do something about the spam problem that we have. And we can't do that. We're not in control of email. We don't run a global mail server that we can then put appropriate controls, blocks, and filters on. But in many cases, there is also crossover. So counterfeiting is a perfect example, because often counterfeit goods will be sold off a website that has some sort of squatting problem. So you can go, you can use the UDRP, you can get, hopefully, the squatted name removed, but it doesn't deal with the underlying problem, which is how do you deal with the goods? So ICANN is playing its role, whether it's as well as it could be, whether its role needs to be improved or some of the processes need to be improved is given. But it's got to be a collaborative effort and approach. So then the question is, how do we create structures to deal with these orphaned issues? How do we find owners? How do we force people to take them? Because otherwise they keep coming back onto our plate and we don't believe it's appropriate for us to deal with it. So I haven't yet been asked why I'm wearing a strange badge on my lapel with the term OneNet, but the OneNet initiative is one such approach. So what we have done as ICANN is work with the other ISTAR organizations, so the regional internet registries, the guys who hand out names on a regional basis, ISOC and the IETF, and we came out with a Montevideo statement, which was essentially saying, we recognize there are these issues that need to be dealt with, and we're going to be working together to try and find an appropriate vehicle or mechanism to deal with some or all of them. It's not necessarily a single vehicle, there might be multiple vehicles. That initiative is known as OneNet, and ICANN is one of the incubators, together with its ISTAR partners, of OneNet. But the idea is not that OneNet is an ICANN subsidiary, but rather it's an initiative, and when it has its own legs, we will let it go and let OneNet continue, hopefully, on a productive, independent basis to go on and deal with some of these issues. But it's also led to the Brazilian president suggesting Brazil hosting a conference, which is now taking place, called Net Mundial. And Net Mundial is scheduled for, I forget the dates, apologies. I think it's late April. Mid-April, late April. But the idea is, and as a government invited and hosted event, bringing in some of their BRICS and other partners, the idea is for government to start having this discussion about where do these orphaned issues go, but also to push through to some of the existing actors to say, these are what we believe your roles to be, but also very encouraging that governments are willing to have a interactive discussion with some of the existing players. And while not quite treating us as equals, because governments never do, at least they're willing to have a dialogue and an interaction rather than in some of the existing intergovernmental organizations where it's a government-to-government dialogue and the private sector can sit in the back of the room and pass notes to their government, if they've got a friendly enough relationship.
Thanks, Mike. Let me just follow up a little. One of the questions that I get on this topic a lot is why, given that there's been this kind of cycle of interest and discussion of internet governance, why is this all happening now? And really, what is the primary relevance to the folks in this room of these discussions?
Well, as I said before, these discussions have come and gone in waves. There was a significant peak of interest around 2005, 2006. It's dropped off. But I think in particular the Snowden revelations in the last year and queries about who's using what infrastructure for what purposes has raised these concerns again. The Brazilian president obviously was very het up about the fact that her personal communications may or may not have been intruded upon. That led to her making some grand gestures and also making some statements, and she's been convinced through the excellent Brazilian Internet Committee to look at a more holistic approach rather than reacting specifically. But those of you from the US will see that one of your representatives, Senator Rubio, announced at Google's offices in Washington yesterday that he's going to be launching legislation in the US to prevent the United Nations taking over the internet. I don't know which of his staffers gave him that speech and how much of it he did or didn't understand, but because the issue is getting raised and is bubbling up, so people are climbing on the bandwagon and the calls and the talk starts escalating. There also was a very significant ITU conference that took place last year, which also raised the temperature in the space in terms of whether the ITU is or is not the appropriate vehicle for some of these discussions. And that's why it's kind of hitting a boiling point at the moment. And then depending on how cynical you are, you'll either say it'll come off the boil when something more important distracts the politicians, or you will say, no, it's actually reached a critical point. It's boiling now. We have to be involved, because if we're not involved in setting the agenda, then those with very specific interests will set the agenda, and the business community, the trademark community, or a more general, reasonable, logical community will be left out while the special interest groups push their own agendas.
Mike, can I jump in and ask you a
Please.
question? Was it ever considered by the board to, instead of joining this debate with the governments, to say to them, the IANA function, this is nothing to do with Snowdonia. This is about a technical function, because that's one thing which I've heard several people in the IP community, particularly now brands are applying for registries, saying, why did you join the debate? Was it essential for you to do it?
We felt that it was essential. Given where the US government is at the moment, given the initiatives, and given some of the suggestions over the last 12 to 18 months, we felt it was actually necessary. The reality is that the IANA function, this critical database that underpins not just names, but also numbering and protocols, is a public resource, but not an American public resource, but a global public resource. At the same time, you don't throw a global public resource into the wild and say, well, it's global, here we go. No, nobody needs to look after it. Nobody needs to make sure that service levels are adhered to, and it functions in an appropriate manner. It's very difficult to sign a service level agreement with the global community. And that's why up until now, as the relationship between ICANN as the IANA provider and the US Department of Commerce has stretched, the question now comes in, so if we're no longer contractually bound to the US DOC into the future, who do we sign with? Who do we commit to in terms of our stewardship of this critical database and this specific function? And that's really the question that's being thrown out at the moment. Maybe the answer is, no, go back into your hole, stay out of this. You're getting into places where you shouldn't be. Stick to your knitting. You've got a very specific and very focused purpose. Don't do anything else. You're making a mess. And if that's the message, it's a worthwhile message to take back and say, guys, maybe we're stepping in places where we shouldn't be.
I mean, part of the problem, I think, is that it's not just who you're contracting with for the other services, but who you're right now demanding contract with you. And that's the connection, I think, to how this has all come up. I mean, these new TLDs, good idea, bad idea, I can love it or be frustrated with it, now has raised the specter of some very deep pockets, or at least perceived deep pockets, of what all these TLDs are doing. Governments are suddenly waking up to, they're invited in to comment on the rights protection mechanisms, but then they overstep because suddenly Brazil doesn't want Amazon or something in, and so the governments are waking up to, wait a minute, there's this big deal out here, and maybe you shouldn't be the ones to run it. So I think in many respects, ICANN is not forced into the discussion. I think ICANN invited the discussion by what happened. But I think the other problem and frustration that we have coming from the TLD and representing brand owners is we were told, and we had to explain to our clients, that you have to contract with ICANN. And I spent a whole lot of the first years of this process trying to explain to people who ICANN was and why they even had any authority to demand $185,000, much less, who owns this, and how come everybody isn't suing them to take it away? And now we've talked everybody into, okay, necessary, got to sign the contract with ICANN, let's work it out. The brand registry agreement came up with a better agreement rather than a less agreement. And now suddenly we're being hit with, wait a minute, you're contracting with somebody who may in fact not be running the internet after all.
Well, ultimately, we don't run the internet. We coordinate a very small and specific technical function. And the reality is that names do have an impact, especially in the trademark sphere. They have commercial value, so that's why we attract a little more interest than some of the other highly technical functions do. But ultimately, we coordinate a small, focused technical function. And there are a lot of people who keep saying, why did we get into this? Why did we agree to throw open the new GTLDs, even the previous rounds? It just attracts more attention. Why can't we just continue to perform our key technical coordination function well and let other people handle these issues? But you're right, we have invited it on ourselves by opening up, but it's also what our constituencies wanted. It's what the brand owners wanted, it's what the registries wanted, it's what the registrars wanted, it's supposedly what business and users wanted. Hopefully it's pro-competitive.
That could be a whole nother hour and 15 minutes.
That's a whole nother one, Eddie, you know.
Agreed.
And then you've got that whole multi-stakeholder bottom-up thing going on. Okay.
Well, there was some confusion as to whether it's bottom-up or bottoms-up. Seeing as we're in London, I suggest we wait until after 5 o'clock, get something to drink, and we go bottoms-up.
Multi-stakeholder and bottoms-up or bottom-up suddenly somehow got divorced from one another when they used to be synonymous. But Martin.
Just to add on to those points, though, because I think the technical aspect is a very limited view. It does have such an impact on everything it touches, and the players that ICANN has contracted with in the past and is due to contract with in the future is increasing that exposure dramatically. So there is certainly an element of coordination, if not responsibility. And I kind of liken it to the conversation earlier between Jay and Fred as, we've got to take responsibility in this space and try and work things through, not rely on somebody else to do it. Rather than let the problems get too big, how do we work together? And I think ICANN itself is a very good nucleus to bring together those players, if not necessarily the responsible party to correct those situations.
Right, and I would actually agree with that, and I realize this is somewhat kind of a trademark heresy, but I do think that there is a real danger to ICANN going above and beyond and addressing some of these other issues that you were mentioning, like spam and counterfeiting, because I think once you let that genie out of the bottle, it's going to be really difficult to put it back in. And I think as long as we have a relatively discrete and I think generally common understanding of what the parameters are of ICANN's responsibility, I think you can have the community working together for the most part, kind of rowing the boat in the same direction. But I think above and beyond that, you can really have some issues. And I think this is a topic that we recognize could take the whole time. So we're going to cut this off and move on to a related issue that deals more specifically with new GTLDs, but you can certainly ask questions at the end. We're planning to have plenty of time at the end. And that is the intersection and the implication of new GTLDs for the public trust.
Sorry to interrupt you. Just maybe to conclude over there, I think the comments you made, Christina, are very accurate. I was taught as a young attorney, I'm sure most of you in the room have had similar admonitions at some stage or another, that in a courtroom during cross-examination, in particular, never ask a question to which you do not know the answer. And one of the concerns, and it's a very personal concern that I have, is that we're asking a whole lot of questions here to which we do not know the answer. And that makes me scared, because we're kind of throwing some serious, difficult questions up in the air and hoping somebody's going to grab them and run with them. But what happens if we just raise them and nobody grabs them and run with them? And that, to me, is the scary issue.
Indeed.
So I'm going to talk about trust. I'm going to talk a little bit about the application process, and then I'm going to talk about three particular issues about trust. Last weekend, I heard someone give a speech, and he started off by quoting Mark Carney, the the current governor of the Bank of England. And Mark Carney paraphrased a Dutch saying, I believe, where he said, "Trust arrives by foot, but leaves by a Ferrari." And I think that's quite relevant to where we are at the moment, because we're looking at each other on the panel, you're looking at us, and everyone in the ICANN world is looking at everyone else, thinking, who do we trust in this whole process? So background then. Important to talk about it and to talk about trust, because 2 weeks ago, I think, Akram Attallah, who is the president of the Global Domains Division for ICANN, announced that the second application round would begin as soon as the end of 2015. Now, we don't know what that means. That could mean the discussion about what's going to happen begins at the end of 2015. It could mean a new guidebook. It could mean lots of things. But what's clear is this is not the first and only round. There will be a second round. It's going to be evaluated, but I think the sheer scale of the number of applications means that there will be a second round.
Well, if I can add, it's not even intended to be a second round, but rather a continuous process. If we get it right, we may be able to get to a situation where we don't have to break between rounds.
Yeah.
Where
I
it
love
then
that if
simply
we get
becomes
it
a
right.
process.
Well,
Well, Ellen, we discussed yesterday, lessons learned need to be implemented. But if we learn well enough and implement well enough, then hopefully just minor tweaks are required going forward, and you can just push them through. But I interrupt.
okay. So as you can see, there were numerous editions of the applicant guidebook, and some of you probably read all the pages. There was a fit and proper person test for people who are going to apply. There were prohibitions on some strings that could be applied for. There were 300 comments periods. Some of you, Christina probably notably, replied to each one of those, putting in the view of trademark owners on behalf of INTA. So there was a lot of debate about this. So I think it's very unfair of anyone to say that this programme was not born slowly and nurtured to the point where when it came to life, it was something that we didn't know was coming. It was very carefully worked out. What was a surprise was the number of applications. I believe, or I've heard people within ICANN say that they expected around about 500 applications. They got nearly 4 times that amount, so 1,930 applications. With that scale of applications, one of the big casualties, or first casualties, was predictability. Because if you're an applicant, ICANN's process did not imagine that there would be so many applications. So lots of issues came along. Some of you will be familiar with terms like name collisions or auctions, the objection processes.
Digital archery.
Yeah, digital archery. Timetable for all of these things suffered.
Expressions of interest.
And I think because of the scale of the number of applicants, and because brand owners in particular turned up, everything became more complex and predictability was sacrificed. So I'm going to talk about 3 issues of public trust, which I think are illustrative of where ICANN needs to re-establish predictability. And alongside predictability in the world of ICANN, there's transparency, which is really very important, and then there's trust. And if any of you have got clients who applied, or you're thinking of applying in the next round, then the ability to take part in a stable process with steps which are as laid out in an applicant guidebook is really very important. So the first issue I want to talk about is the issue of open versus closed. The guidebook suggested that there were, or stated that there were 2 types of applicant. There were standard applicants and there were community-based applicants. There were no open registries or closed registries in the guidebook. But brand owners turned up. Brand owners applied for terms. Brand owners applied for terms, for strings, that when community read the applications, which were published in full, transparent and good, then people saw that these registries were not going to be selling domain names to the broader public. So what happened is that registrars who make their living by selling domains to as many people as possible started to complain about this. They wanted access to what they saw as the prime internet real estate. And then what happened was that the governments started to pay attention, and the IP community jumped in very quickly. And so this debate began about business models. The guidebook allowed anyone to apply for, well, almost anyone, to apply for almost anything. There were no restrictions on business models, but this debate began about business models. So should an industry player be allowed to apply for the relevant industry term? Should they be granted a perpetual virtual monopoly over a string in the domain name system, which applies across the world, which is relevant to their business?
Can I just interrupt for a second? For those of you who may not have memorized the registry agreement that ICANN has for new GTLD applicants, the reason Nick is referring to it as a perpetual monopoly is that it effectively is. The registry agreement has a 10-year term with a presumption of renewal. So in effect, and I think historically it has been the case, that once a registry operator signs a contract with ICANN, that contract effectively never terminates.
I can give an example from one of my clients. One of my clients is the Cruise Line International Association. It's the professional association for the cruise industry. And they applied for .cruise. That's a non-controversial example. That's all you're going to get from me.
All right, so I'll give some.
There are others.
I mean,
There are others I can think of.
People question whether or not Google should be allowed to apply for .search, whether or not Amazon should be allowed to apply for .books or .music. Who gets apps if it's not, donuts or some, non-particular industry body, that kind of idea.
Yes.
And what term, just for the audience, what terminology are you giving that kind of application? Closed, generic?
Closed, yeah, a closed application. That will be closed because Cruise Line International Association, for example, wants to use it as a kind of trust mark. They want to give domains to their members to indicate to the cruise going public that the owner of the domain name meets standards of safety. So that's a kind of positive example.
Well, maybe just to add to that, the traditional pro-competitive approach is that every registry must make names available to any accredited registrar on an open basis. But in particular, because of approaches by industry associations as well as brand owners, who turned around and said, it's not really appropriate for us to open to every registrar out there because they may not be able to go through the vetting criteria that we want to go through, or a brand owner who says we want to use our .brand only for internal purposes, and we don't actually plan on selling our .brand to the open market, and we think it rather ridiculous that we would have to go to a registrar to buy our own names for us. Can you imagine you apply for XYZ brand, you XYZ, but you have to go to a registrar to register product name.xyz brand. It's crazy. So we created an exemption and an exemption process to deal with that specific request from parts of the community, in particular from the brand community. What happened is some players then saw that and thought, well, this is an opportunity to gain exclusive control of some of these generic terms, while it was intended that the exemption would really apply for .brand applications. It wasn't exclusively stated, and various people suggested that they would apply for the exemption.
And beyond just like, for example, not to pick on one company, like Google could apply for .google, but could also apply for .search. It owns .search and close it and register subdomains only to whomever it wanted, right? So this became an issue.
Yep.
This is an issue right now.
It's absolutely, and I think part of what happened here was the fact that it was also secret, because nobody knew who was applying for what into the great reveal day. And then suddenly you see, again, to the point of predictability, well, we kind of thought the brands would be applying for their own brands. We kind of thought that there would be domainers out there who wanted to get generic terms. But suddenly waking up and realizing how many brands we're also going for generic terms and having businesses who might have considered it or who never considered it, and then on reveal day suddenly had this major wake up of, oh my God, you know.
I just should ask this question. How could it conceivably be in the public interest to allow a private company to have a closed dot generic? Conceivably,
there.
in the public interest. Really?
Give us a minute.
All right.
Nick's going to get to that.
Well, I mean, I think you can argue, and I have argued, that it's not anti-competitive until there is a pattern of anti-competitive behaviour. So is applying for .cruise different from owning cruise.com? I mean, this is playing out. And one of the things that happened is that governments jumped in, ICANN responded, and it's become mandatory upon applicants to sign up to what's called a public interest commitment, to say that these registers will be run in the public interest. And there is a dispute process going forward for someone to challenge registry owners who have made this public interest commitment and then breach it. And we'll see how that goes. I'm just going to keep moving, because I think these three issues then lead into what other people are going to be talking about. So the second issue was about regulated industries. The GAC is the Government Advisory Committee of ICANN, and they became very concerned when they saw that list of 1,930 applications for the right strings to get into the right hands. They sent out what they called early warnings. They sent out just over 40 early warnings to applicants for strings that matched a regulated industry, so to .bank or .insurance. Now, for many consumers and many rights owners, this was a good thing. This is kind of quite right. It's about the protection of consumers. It is about public interest. But it kind of left me and some other people wondering who's in charge, because we paid ICANN the $185,000. We signed up to the guidebook, and suddenly these governments, who are an advisory board to ICANN, started coming in sideways, saying, we want you to make a commitment to us about how you're going to be doing this. So any of you who are thinking about applying in the second round, you need to think very carefully about this, because some governments are seeking, I might argue, a supranational veto over the strings that can be applied for. And I think, going back to what you were talking about, that's quite worrying. The last issue I want to talk about is the secondary market in top-level domains. So what this means is someone applying for a string, and I've used there the example of Deutsche Post applying for .trust, but the application being bought by a third party before the string is turned into a registry, before it goes live. Now, ICANN carefully evaluated every application. The community was allowed to comment on every application. Accountants viewed the business plan of the registry. Registries position themselves to be, although these are terms which I don't particularly like, open or closed. So I think there's a very big issue here. There's no large debate. I know it's something that Christina's very concerned about, and rightly so. But you could imagine a situation where Deutsche Post, for example, applied for what would be termed a closed registry, keeping the names for its own use in support of its own business, but Artemis want to run it as an open registry selling domain names.
In fairness to ICANN, and that's not a phrase I use often, so make a note of it. I will say that this is an issue that concerns me. It's concerned me from the very beginning, because it could easily be an end run around all of the evaluation. There is a process in place at ICANN, I don't know the extent to which it's actually ever been used, that sets out the various types of transactions or changes in control or sale, and what level of subsequent evaluation is triggered. So the framework is there, but given that it's never actually been used, I think it's very much an open question as to how thorough it will in fact be. But I would venture a guess that the secondary market is probably the next big issue that we're going to see coming down the pike. Go ahead.
Sorry, I just want a point of clarification first of all. I think it was David. I think you're hidden there with the microphone.
I'm hiding up here.
Thanks, David. I know Nick looked towards me when he mentioned .bank. I've not applied for .bank. Okay, so I just thought I'd better clarify that. So that's not HSBC applying for .bank. The other point that I'd like to add on, though, is that in amongst all of this is putting it into some context, is that when all the new GTLD application process was emerging, there still wasn't that much in terms of quantities of business turning up at ICANN. They've obviously been very wary, very afraid of going in through the door of ICANN and emerging themselves in that space. So I think it only really came about on the reveal day that the levels and then shock sort of set in. And prior to the applications coming through, there was no segmentation, no idea of the models that were going to come through and how to deal and treat with those specific types of models. So it was, as Nick referred to, available for anybody to apply within reason for anything.
If I also just want to say something about the government role and Nick's comment about government veto. I mean, on the one hand, the trademark owners invited the GAC in. The GAC had actually been the Government Advisory Committee had been very silent and then suddenly started to stand up for rights protections. And that was great until they started to overreach. And then it was like, oh my God. And then you think government vetoes. Well, if you want to give a government a super veto, well, maybe you think that's an important role for governments and that brings in the ITF. But then, which governments are you willing to let do it? And there's some very politically correct governments that may be weighing in. But there are others that aren't. And, is the U.S. going to be viewed the same way as Iran? Or is England going to be viewed the same way as China or India or however it's going to be, or the South American countries? So it gets very touchy.
To some extent, I think you're absolutely correct, Ellen. All of those people who ran to the Hill and lobbied their representatives, I think may have gotten more than they had bargained for by getting politicians involved, because politicians give orders to bureaucrats who sometimes execute more efficiently than we would like.
So let's transition now from kind of the broader issue of public trust to rights protection mechanisms, which have been a very hot topic throughout this whole process. Ellen?
Right. Thank you. The whole reason that this public interest happened and that it's tied to rights protection, not the whole reason public interest, but, and David, I would even question what's in the public interest. I guess there's a big debate about what constitutes the public's interest and which public we're talking about. But certainly for trademark owners, we cared a lot about trademark rights. And in fact, when this whole process started, trademark rights were being defined as one of the 4 overarching principles. So all along the way, we understood that trademark rights were going to have to be built into this new system. And so, and more than that, if it ties to public interest, because we as brand owners, or at least people who believe that trademark rights are good things, are here because we think it goes to consumer protection and trust. And so the argument for why it matters that they're there is not just because of piggy brand owners, but because they think that trust is good for the internet. And so in developing these mechanisms, and the term tapestry will always remain both dear to my heart and parody, has to do with the fact that rights protection mechanisms were built in, or attempted to be built in, both from the front end and from the back end. So in terms of the front end, there are procedures that were set up that allowed people to object to applications that were coming in, and they could be done under legal rights, which is where the brand owners usually sit, string confusion if things look too similar, limited public interest, of which, again, there's some debate, and community objection, which meant if you applied as a community application, you got jumped to the head of the line of an individual. But then the question is, who then represents that community? So if you're going for .banks, you want to give it to the right community for banks. So there are lots of people who are claiming to have represented communities, of which there's great debate on who owns the community, .gay being one example of that. And then, as we said, the governments woke up and added some of theirs, and the independent objector came in to suddenly have his ideas about what might be objection. And here's some stats about the kinds of objections that were raised. But the tapestry of protections that we tried to build in we're attempting to deal with a number of problems. The first that's labeled as part of the protections, and you'll see that ICANN calls it a rights protection mechanism and we don't, is the Trademark Clearinghouse. The Trademark Clearinghouse is a data registry where you could validate and register your trademark rights so that you wouldn't have to do it again and again, but it was meant to be a tool to allow you to then use all the other rights protection mechanisms. There are sunrise registrations that are mandatory. Everyone has a period in which brand owners can jump in. There's the IP claims notification that if you're registered in the Trademark Clearinghouse, that you're at least notified, and for different lengths of time, depending on how long it lasts, of other people trying to apply for your names. The URS, the Uniform Rapid Suspension System, was developed as a fast takedown that was meant to be for slam dunk cases, different than the URP, but to fill in a hole that was left there. The ability to post-delegation dispute resolution procedure to challenge something. Common example being if the Apple Growers Association got .apple because they were a community and they jumped ahead of Apple getting .apple, what happens if later you find out that they're actually selling domain names that deal with computer products? And so that was supposed to address that. The community registry restrictions dispute, again, to argue about communities, and the UDRP, which continues. And this is not going forward. That was our slide of what the trademarks protection mechanism is. This is interestingly ICANN's. So ICANN is officially calling the Trademark Clearinghouse a rights protection mechanism, and every time they try and tout how well and how much trademark owners have won in this battle, they keep pointing to this and say, well, we gave you all these mechanisms, we gave you all these mechanisms. Some better than others, some as good as we'd hoped they would be, some falling short, but after community debate, but a lot have been addressed. Here again is another official ICANN slide talking about how the Trademark Clearinghouse is an important rights protection mechanism. And then in addition to the ones that ICANN is mandating, a number of the new registry operators are offering their own, which means it really matters that you know who will be running the top-level domain that you may be interested in getting to, because there are others who, although they had to only comply with a minimum, I'm notwithstanding hoping to create a space in which, by offering additional protection, will make you want to go in their direction. So Donuts has created domain protection, the DPML, that was its attempt to do what we tried to do with the RIT and did not succeed in doing, was coming up with global protections that you can pay to have your trademark blocked in all of their domains. Google has an extended sunrise and an ongoing trademark claim service for theirs. Uniregistry is offering a cost recovery block if you attack there, and that you get a once and for all unified registration application process with them. ICM has automatic blocks that you can pay to be blocked out of there. And so there are additional protection mechanisms to the official ones.
Thanks, Ellen. So what would you say when someone comes to you, as I'm sure they have, and they've come to me and said, so I am hearing about, I don't know, there's 120 new GTLDs have already gone live. There's going to be another 1,200 over the next 18 months. I have a portfolio of 1,000 registrations that covers 120 countries. What do I do?
And this one is really, I mean, it's a good question, it's a tough one, and I think at the end of the day, a lot of businesses are actually looking down to the dollars and cents of it. It wasn't clear initially that I would recommend to people to go running to the TMCH to register, and certainly all of their stuff, because it was expensive, and by the time the rights were going to run out, the claim service and some of it, it wasn't even clear that the new TLDs were going to launch before that ended up. Then the TMCH decided to extend it so that they would make it more cost effective. Some of the clients are waiting to put it in once they see, as they get closer to the new TLDs of the ones that they might be considering. And some may have specific registrations. I mean, you have your registration in the US, but if there's something comes in that requires you showing a Japanese registration, well, then you'll have to do that. And then there are others who, rather than doing this proactively, are going to wait and just spend money on takedowns. So I've got them all over the board. What's been your advice?
I actually tell clients to look at the list of TLDs and work backwards. In other words, which ones do you care about because you want to actually have a registration there? Which ones do you care about because you want to make sure that no one else gets your registration there? As a practical matter, the DPML is actually extremely cost effective. It doesn't necessarily apply to all marks. But if you look at the donuts portfolio, which is extensive, obviously, and you do on a per TLD basis, it's cheaper than a Sunrise. So for clients with bigger enforcement budgets, that makes sense for them. For others, it really depends on where are you having your enforcement issues. You know, you're certainly not going to put all 1,000 trademark registrations in. But if you consistently have enforcement issues in, for example, China, and you have a registration of your mark in Chinese and in English, maybe you put both of them in. Or if you have enforcement issues in Latin America or in the EU, put in your CTM. You know, I think how the TCMH is handling in Madrid registrations makes it a little tricky to use those. But by and large, I think it's that part is easy. What's difficult is the fact that every week there's literally another 30 new TLDs that ICANN is posting their Sunrise information. So you really do have to make sure that if you're not on top of it, that somebody who works with you or for you is.
Absolutely. And I think that the important point that you raise is just don't go run. Everybody was running fast and wanting to spend money. And a lot of what we've said is slow down and work smart, because you can't function the same way that you did before this new rollout. It just wasn't scalable. The registering everything, to try and do everything defensively, whatever, but to really sit down and look
Right.
which ones you want, which ones matter.
Well, and also keep in mind that once they're in for trademark claims, you're going to get a notice of registered name whenever anyone registers a domain name that matches one of your marks. And I'm getting about 200 of those a week. So, you know, and then you have to stay on top of those. And then you have to deal with the issue of, I'm a trademark owner. If I'm not going to go after these people that I get notices of registered name for, am I creating a laches problem for myself? You know, these are all things you have to think about. Martin.
I think one point to remember is that some of these are still fairly new and untested as RPMs, and in particular, I'd be keen to know how we understand if the claims notices are actually being triggered effectively all the time. I don't know how that is controlled effectively. But beyond that, the donuts DPML, okay, it costs, but it's better than having to register under Sunrise all of my brands. But I distinctly remember this being an issue within ICANN to say it can't be done. And so I think I'd like to know, and perhaps, Mike, if you could give us an idea of how does the community then work this back in and say, hang on, we've tested now, we've road tested something, and if in 6 months we're happy that it's actually functioning very well, and I'm not sure whether donuts will declare what they consider as a success or not in that space. But from a community's perspective, if it's shown and proven to work, how can we then adapt that to and globalize it across all of the GTLDs and take it away from someone like Donuts that is obviously still benefiting off of the registrations within their own DPML?
I think it's an excellent question, and it goes back to what Nick was talking about in terms of trust. Because every time we make an ad hoc change, I can tell you we as the board cringe, because we keep promising ourselves that we're not going to make changes, but then there's an urgent need which we have to do, and we look at this and we go, we've got to stop doing this. It was fixed, and each time we've opened the door a little bit, it opens the door wider for something else. In this case, I think donuts are able to offer their protected marks because they make the rules as to what constitutes a globally protected marks, a globally protected mark or a mark of significance which would allow for global protection. The part of the issue is that there wasn't community consensus previously on what would or would not go into the GPML. And part of the issue there is it's trying to maintain this bottom-up consensus-driven approach to policy making. And what people didn't touch on is that we're at the moment, one entity, a non-commercial entity within ICANN, has initiated an independent review of the decision to look for the Trademark Clearinghouse at trademark plus variations. They wanted to go exact match only. Now, we're sitting trying to create a balance. And to me, it's often like being a parent, of dealing with children who at totally opposite end of the spectrum. And you're saying, go back into your room and sort it out yourselves. And they come back 2 weeks or 2 months later and say, we tried, we can't. And ultimately, sometimes you make a decision on what you think is right based on the feedback you're getting from all the various groups. And you make a decision and somebody says, no,
But part
that's
of it
wrong.
also, I think, to some extent goes to trademark rights were declared an overarching principle. And so what do you do when you've labeled something an overarching principle and how to balance it? So it really isn't. I mean, the other thing that you touched upon, Martin, is not only do we not know how these are going to play out, we don't know which of these TLDs are going to succeed financially. So, to go running and do sunrises in every top-level domain when it's not even clear if they're going to be financially viable or make it is another question.
At the same time, I think there was something that was very attractive at the idea of a globally protected marks list, which meant
If you
pay.
made the list.
Yeah, if the list was possible, the notion of pay once, protect everywhere. So you don't need to go and start going through this exercise of saying who's going to succeed, who's not going to succeed, where do we choose to put our money and effort? We'll pay a slight premium, but we're protected everywhere, was very compelling. But we couldn't get agreement on what the standard would be to then create that. The one comment that I do make, because my background is in the country code names community, is which of your brands have you registered under .zm? Zimbabwe. Yeah. Have you gone and gotten a registration in Zimbabwe or Ghana? Well, if you haven't, and I'm assuming there's good cause for it, because you don't have local presence, you don't meet the requirements, so you don't have a market over there. Well, then ask yourself exactly the same question when you're looking at the list of new GTLDs, and don't take a different approach to what you're doing, or a chicken little approach, the sky is falling, we have to register everywhere. And I think that advice is absolutely correct.
Slight caution there, though, in terms of some of the country codes are not marketed easily within the registrar space anyway, so they're very, very much off the radar unless you do business there, unless you're local. So some of those are...
A point very well made. I just think, though, the corollary, though, is some of these new TTLDs may land up not being particularly well marketed either. They're going to desperately try. And maybe .guru and .ninja will get, some quirky community support, but some of them, I question those business models. And I know that sitting on the board I shouldn't, but I look at them and go, well, I really hope this is sustainable, because I think the first failure is going to be embarrassing for us. And I'm expecting it to happen, and we'll deal with the embarrassment and move on. And then we make sure that we've got our emergency protections well enough set out, and I believe we have, but still, it's one of those situations. Every industry gets a little bit red-faced when one of their colleagues goes under.
Right. Just kind of put a marker down for an issue that I think is going to come up quite soon in ICANN relating to RPMs is what happens when an applicant tries to provide or design its sunrise process in such a way as to essentially be exclusionary. And more specifically, for example, I'm sure you've all heard of the .sucks TLD. You may have also heard that the CEO of that TLD, who actually happens to represent the business constituency on the ICANN GNSO Council, which is a discussion for another time, that he has said that sunrise registrations in .sucks are going to be $25,000 each. So Senator Rockefeller it's been a topic that's been picked up by a lot of the domain press. Senator Rockefeller wrote a letter yesterday about it. And under the guidebook, each GTLD registry has got to submit its TLD startup plans to ICANN for review and approval. And I think it's going to be really important for everyone in this room and for everyone that you work with outside of this room in this community to be watching that very closely. Because if ICANN says, sure, you can charge $25,000 for sunrise registration, you've basically undermined the entire RPM. So with that editorial note concluded, Martin.
25,000 for the Sunrise, but not 25,000 once it opens freebie.
Correct. Correct, exactly. Exactly. So, Martin, a lot of folks have said that a .brand is the ultimate RPM. So why don't you talk to us a little bit about .brand applications and where brand owners fit in the new ICANN?
I may have to take you back to a little while ago when it wasn't so confusing in the world of internet governance that we've gone through already. New GTLDs emerging. This was going back to pre-new GTLDs days, or just on the verge. So in 2008, I opened the door to an ICANN meeting in Paris because it was close to home. Train journey down. Thought it'd be easy just to go and see what this thing is, because I was immensely confused with the website, what it did, but essentially, how do I stop our brands being abused online? How do we stop phishing? How do we stop cyber squatting? That's what I wanted to try and do. I was failing in most other avenues to try and figure out where to find a home to this. So it probably does resonate with some of the earlier conversations. So I went along and planted myself in the business constituency. I'm from risk management area within the bank, and whilst there's some synergies with the intellectual property area, business seemed to be a good home for me, certainly at that time. But it was a difficult place to navigate, and I can understand why there probably isn't as many, or certainly wasn't then, as many organisations directly facing off to ICANN. Instead, they tended to do the traditional thing, which is work with a trade association so that they can represent your views. This is a concern to me, and always has been, is that as ICANN tries to work out policy, and it's in this space, this GNSO space, which is the key policy area, is that how do you balance all of these different opinions? There's contracted parties to worry about. They've got one extreme, business, IPC, another extreme, and then you're going at a different angle with non-contracted parties that are looking at specifically the users and non-commercial areas. So it's being stretched in all quarters. With that, I did plump for business, but as the new GTLDs started to roll through, after a certain degree of panic, I thought that it was actually a very good idea for certainly HSBC to pursue. And I think it's useful because we're hearing about different models, just to try and can we frame what a .brand is and try and relate it to some of the things that you would within a registry, current registry area. Easy one to start with, it relates to your trademark. But it's not our core business, so it's something that will help support our business, very much like the domains do that we already utilise at the second level, but this takes it up to another level. But there's no intention to sell domains, there's no issues with who we're going to hand them out to. They're all going to be within our organisation and trusted points that would be able to utilise our own registry. So the essential point here is that it's not something that we're doing on a commercial basis in terms of running the registry. It's actually to facilitate. It's a piece of infrastructure that we can use for the benefit of our organisation and for the benefit of our customers, and will enable us to have far greater control, security, and those sorts of layers that will enable the trust or further trust to be passed on to the customers. So as we went through the new GTLD applications and they all rolled through, this starts to get a bit confusing as to where's your home now within ICANN. Am I a registry? Well, I'm not selling domains. That's their traditional model. That seems to be the type of people around the table when you visit a stakeholder group just filled with registries. There's not that many of them, fairly well dominated. Are we a business? Well, yeah, we are still a business, but we've got this additional link now where we're contracting with ICANN. So we're not just getting a domain name. We were always at arm's length from ICANN, but now we're hooked up under contract. We have obligations now that we have to cover off, and different interests, say from an intellectual property perspective as well as a business perspective. So we have to start considering, where do we fit in that picture? And essentially it could be across multiple points. But that probably mucks up the whole voting process, trying to get that balanced debate that the policy process requires and the board requires to make some sensible decisions. So it's not straightforward. If I move from a business constituency and if others move from an IPC constituency over to the registry group, are we at risk of diluting some of the voting and power within the non-contracted parties' house? If we move into the registry stakeholder group, is the weighting of our votes any use at all? Because if there is disagreement, and there are going to be disagreements because we're running completely different models, our votes are going to be on the basis of volume of second-level domains. Well, our interest isn't to sell millions of domain names. So there are all sorts of these issues that are under discussion at the moment. The brand registry group is trying to work through with the registry stakeholder group and others to see how and where best to fit a .brand entity. But it's very much like a square peg in a round hole at the moment. So that certainly prompted last year the formation of the brand registry group, so .brands could get together collectively to work through some of the issues which they shared. Certainly there's a key issue that's been around the contract, which is fairly well based on the standard open commercial registry. So in ourselves, we want to be recognised within the ICANN community. We are not a formal group within the ICANN community, so we're not established there. We are a trade association that sits outside. But because we are a vast quantity of applicants in this first round, and probably the majority of applicants in the subsequent rounds, it is important that we find a suitable home and feel that we are being listened to effectively. We have a lot to bring in terms of changing and adapting ICANN to meet these new models and new entrants that they've invited in. So this is a way for us to start forming those opinions, help streamline processes with ICANN as ICANN adapts and grows, which has had to do fairly rapidly in the last year. So the luxury of a brand registry group is that it actually sits outside, so it can be a bit more nimble than the structures that sit within ICANN. But we'll be looking at best practices and building up some good ideas to take forward to ICANN and collaboration with other actors within this space. What was that? Yeah, I think this is just to be aware of going forward. This is just an example, but for brands, it's not an easy ride. I mean, there is uncertainty all the way. And we've got to learn from the lessons through this first round and see if there are better ways to improve the predictability of subsequent rounds opening up and being applied for. But, just because you have a trademark doesn't mean you automatically have the right to run a TLD. And certain objections could come from all quarters that you've never really concerned yourself with. And that probably speaks well to the point earlier with not directly with .brands, but in the regulated environment with .bank. It's very difficult to coordinate a sector across the globe to get all the buy-in you need to then go to ICANN and say, okay, we've got the whole community around the globe supporting this. Thank you very much. Can we have our TLD? There's a lot of work required, a lot of behind the scenes of nurturing and making people aware and understand what this can do for an industry group. And so .bank is one that I'm familiar with, and they have done a lot of work with regulators, associations in different parts of the globe so that they can raise the awareness, understanding, so that there is support for them to be able to manage that space very securely and appropriately for those that will be given domain names and allowed to run services from there.
Thanks, Martin. I think we've got a little bit of time for questions. I know we started a little bit late.
Thank you. So this isn't really about rights protection mechanisms, and maybe it's a debate that we think we've had and lost and moved on from. But all of this brings me back to the question of, Mike, you worry that one of these will fail. I think a lot of these will either fail or just become irrelevant. I mean, maybe they don't fail economically. But, how many people are registered in .biz or .info or .nom or any of the other GTLDs that we have? And I'm very concerned that as we have hundreds of new GTLDs rolling out, the result will just be mass confusion. I won't know whether to go to citibank.com or citi.bank or citibank.bank or citibank.finance or something else. So what will I do? I'll just go to search. And I think that this may be the beginning of the end of the domain name system and pushing us all into search instead of actually caring about what domain names we have. So we've got a fabulous panel. I wonder what your thoughts are on the wisdom of this path, which, of course, a lot of us opposed from the start. We're quite far down it now, but everything I hear about this just makes me think we were right to be skeptical at the beginning.
I think my action is it's either going to prove to be incredibly important or end up being irrelevant, and it's hard to know. I think search and the dependence on search is certainly going to be an initial big piece of it. I think the development of apps is going to affect this. I think if the world moves more and more mobile to apps, then it's possible that this domain space of how we look for things and what we look for will change. But I certainly think that in the near future, even if it does eventually wind down, the same way the .com I don't think is going to go away so fast, even if somebody gets a .brand. I think for a while, the .brand or whatever domains will be a trusted space, or hopefully a trusted space and will matter. I think there will be some people who make killings on things, and I think a whole lot of it's going to fail. But if the whole idea behind this is it's ostensibly supposed to create innovation, I think what gets innovated out of this is really going to remain to be seen. I mean, it may prove that it's a whole lot more of just more people doing the same thing, and then a few companies coming out with doing things that are really, gobsmacking.
If I could just take that slightly different tact on that, because I think that concerns that you mentioned are ones shared by many, many brands, even those that applied. So originally, I don't think I'd be out of turn by saying that a lot of brands would have applied just to secure the name. No ideas what to do with it. But having said that, because now you've got that piece of infrastructure falling into your lap, what the hell do you do with it? That it's going to be different, that it's going to help. And I think that one of the missed opportunities so far is probably tapping into the DNS more effectively. Traditionally, we just see it as second-level domains, people trying to buy up all these names. Think of it as a database. Think of how can you start using that far more effectively, Internet of Things. But if it's controlled within an environment, whether it's a .brand or a very restrictive registry, there could be a lot of positive things that come out of this. And I think this falls back to, how do we get users to trust this space? After messing some of it up for some time now, there is an opportunity to put some order into that space.
The only thing I'd like to add to that is the one thing that we haven't seen yet, and I'm actually very intrigued and curious to see what happens, is we haven't seen any of the .brands do any kind of look for campaign. You haven't seen yet any of the new GTLD registry operators really try and shift consumer attention and awareness to what's to the right of the dot. And I think once that happens at a fairly significant level, I think it could be a game changer. But we're not going to know until we see. But I definitely do agree that at least initially search is going to become more prominent. Did you, either of the other panelists, want to add to that?
Yeah, I'd like to agree with Ellen. I think search is equally becoming irrelevant or less relevant. Many of us, and maybe it's just a reality of focusing on a country code environment rather than on a top-level environment. And I'm sure people in the UK have a similar attitude, which is, do you go look in co.uk or do you look in .com or is it somewhere else? And so a lot more of us rely on search than simply typing in a URL. But I think the appification of the internet is the biggest challenge at the moment. But at the same time, the DNS ultimately supports the apps, and authentication across the DNS is assisted through this process. So it could work hand in glove. But if this process results in more people doing the same thing or the same people doing the same thing with more names, some making lots of money and some losing a bit, I'm going to be really disappointed because competition is not out there. And expanding the space and introducing competition is not there simply to keep doing business as it was done before, but to open the space, to open opportunities to new actors as well as new technologies and innovation. And there I agree somewhat with Ellen. It's not only innovation. It's new actors, it's new parties, it's doing things in new ways by new people. And the portfolio applications, to me, are somewhat troubling because it's the same old people doing a lot more of the same old thing. And I must be honest, personal view, I'm a little disappointed.
And one of the things I think will change, though, that is going to make a difference is the IDNs. I mean, I think the reality of the fact that there's a whole lot of the world who don't know how to function in Latin characters is going to make new players come in.
I think we had Peter Dengate Thrush here a couple of years ago. Russ, which one was that? New York?
Seattle.
Seattle.
And we discussed this issue of the justification for this expansion of the domain name system being asserted by ICANN. The justification was innovation and access. And the cost was the aggregate cost to brand owners and others of having to protect their brand names, of having to register in multiple dot somethings. And so now that you've got the process further along, what's your take on it? I know it's still early, but I think it's the right public policy question to be asking. Is this accomplishing
David,
the purposes?
The internet is built upon permissionless innovation, and it's built upon this huge distributed network without a center. We are going to see changes. I have two clients who I will eat my hat if this time next year at least two brands sitting in a room like this will not have at least 1 million domain names in their own registries. Plans are afoot. Plans are afoot. Companies don't talk about their innovation. They can't talk about it. But they've invested in these things, and over the past years, smart people have been looking at them. The Internet of Things, the internet everywhere, is coming very fast. And as Martin said, the domain name system is this super fast database and a means of sending backwards and forwards information, very granular information. And we're going to see domain names. I mean, maybe some of the issues for us as IP people will begin to disappear. One of the effects of this vast number of new registries that we're seeing in our larger brand owners is they're looking really carefully for the first time ever at their domain portfolios. And as you said, David, .biz, goodbye. .info, goodbye. These new things, we're being really selective because they're looking at their own registries and what they're going to do with them. So it's too soon. Some of the most popular strings applied for, like .app or what are the other ones? .blog, .music, .movies, had multiple applicants, so they're in contention. So we won't see the ones that might really capture the popular imagination until the end of this year or next year going live. But some of those have reportedly got queues of several 100,000 people who are interested in buying them. So
I'd just be
wait to
interested
see.
in Mike's reaction to that. Does ICANN think that this is working?
Well,
They get paid
David,
for every one.
I can only give a personal opinion.
Remind you, there is a business model for ICANN too.
I can only give you a personal opinion, and to me, the cost to trademark holders is a concern. The cost of the public trust and public confidence is what really bothers me. And I think the cost to trademark holders and the impact on trademark holders is part of that overarching issue of public trust. It wasn't just, as Nick was talking about, public trust in the guidebook and the process, but trust in the DNS. And I think that there is a reason to expand the naming system. I was very concerned, and you're welcome to go back and read my reasons for abstention in Singapore, when I chose to abstain on the vote to launch the new GTLD program. And my reason for doing so is because I felt that there were still some elements that had not been fully thought through. It turned out that I maybe was more correct than I had hoped, and digital archery springs to mind. And our new CEO, not being burdened by the sins of the fathers, has come out and said we rushed the program. And because we are where we are at the moment, we need to carry through with it. But yes, I think some of these questions got rushed in the excitement, got rushed in the lengthy process leading up till then. And instead of saying, well, it's still not ready, so there's no point in pushing it through, the fact that it's 3 years late and the fact that some of the applicants have been queuing and sitting on third parties' money who now want to see something delivered is not our problem. This is such a big impact. We need to get it as right as possible. It's not going to be perfect, so we need to launch and iterate. But we still need to do some more polishing. And we also need to recognize that later on, as we hope this becomes an iterative process where you simply then launch further successive waves or eventually a non-round-based application process where you simply put your name into a queue wherever the queue is at that time. That means that you need to improve, and recognizing where you've got problems at the moment is the best way of then improving those issues. And I think we're learning. We've learned a lot. We're still learning. But having launched, we now have to see it through. And then the question is how well we learn our lessons so that when hopefully we launch another round really soon, we've improved and we don't just do more of the same.
I know that we have one more question. I just want to make a plea and an announcement before we take your last question, because I'd be remiss in omitting both. First, the plea. As president of the intellectual property constituency, I am begging, I'll grovel, begging for at least 10% of the people in this room to join. We really need more help. We need more people to be reviewing the ICANN documents that are churned out for public comment on a weekly basis. We need more people who can participate in working groups. We really need more help helping the intellectual property community. The website is ipconstituency.org. Membership for individuals and corporations is $100 a year. So that's the end of my plea. Second, informationally, I just wanted to let you know that the next two, there is an ICANN meeting coming up at the end of this month, but the next two are going to be fairly easy for a lot of the people in this room to attend. One is in the last full week of June, and it's here in London. There's one the second week in October in LA. I would really encourage all of you, if either of those locations is close enough so that you can get to the meeting for a couple days, and this is an area that's either important to you now or you anticipate is going to be important to you, that you come. It's really incredibly important to be there. Sorry, go ahead.
Of course, I have to ask the question now, but I'm keeping everyone from their teeth, so I'll be quick. Interesting point you made, Christina, about educating consumers what happens after the dot. Talking on Martin's point, for a bank particularly where security and phishing issues are so key, do you see, and for the panel generally, the .coms, the .co.uk, the .country suffixes becoming less important? Once you've got your .brand, will you as a bank be able to say, consumers, unless you are within the .hsbc fold, we are no longer liable? And to what extent will that make the .coms for other brand owners less relevant now? Clearly, they're going to still renew them and keep them. They don't want someone else to have hsbc.co.uk.
Good question. The option's available, obviously, but I think it's going to be some time before there would be any major shift by brands to just lift and shift in totality across. Don't forget, our users tend to rely on country codes. Our businesses, all across the globe, there are localized landing sites for them to use, services available to them. But there are opportunities certainly for new services and to roll out on a single platform. and streamline our internal processes, as well as make sure that the user experience is improved by going to one place, recognizing it's .hsbc, easy to remember. So I think there will be some shift over time, but certainly not in the near future. It may well mean that we can offload a lot of the irrelevant registrations, protective registrations, sooner rather than later, and that will compensate for some of the additional costs that we're having to face, either with DPML or registrations in new spaces where we feel it's a risk.
I think that's going to be affected by how fast people seem to be learning about these new things. You know, I think as soon as, if brands feel that people are being educated to move to the right of the dot, they'll do it faster because it'll be cheaper to consolidate. But nobody wants to lose existing traffic, existing customers for people to move to the right of the dot until they see that education. And it'll be interesting to see. I think the registrars who are selling these are going to be doing a lot of marketing about the importance of looking to the right of the dot that I think will eventually help brands as well.
Well, if I can add to that, you only need to look at the number of country code administrators who've put in applications. Some of them in the public interest, and some of them commercial or semi-commercial, for you to realize that they're aware of the threat that this poses. I agree with Martin. It's not a short-term or even a medium-term threat, but long-term, it questions the value, and I think we're going to see country codes spending a lot more money on go local type campaigns, or moving up to the GTLD space and saying, well, if we're no longer getting the attraction that we want out of .za, then we need .South Africa, just as an example.
Well, isn't that what New Zealand did? That they actually think that New Zealanders will go for .kiwi more even than the .nz?
Well, .nz has had a significant go local campaign for a while now, primarily focused on things like .com. So they have a really nice campaign, .nz, it's our home. Nominet hasn't had quite the same needs to market in the UK, but I suspect that the move to the second level in the UK may trigger that as and when they lose trust, or depending if Nominet loses trust with the opening of registrations at the second level. So there's a lot happening in the existing TLD space, CCTLD specifically, but generally in the TLD space, there are a lot of people going, are we still relevant in this new market? And I think that's good. It's good to re-examine what you're there for instead of just sitting and waiting for the registrations to come in and your money to follow.
Yep.
We'll take a short break.
We'll take a 10-minute break. Thank you very much.